Morning, each party will have 15 minutes in which to argue their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know, and I will keep track of the clock and will keep you apprised of the passage of time. We are being visually and audibly recorded. It's been set up to accommodate everybody, so please try to remain still or behind the podium as much as possible here in the front. We have read your briefs and we're ready to proceed when you are.
I'm ready. Good morning. My name is Jonathan Rosenbaum. It's my privilege to appear on behalf of the Petroskys before you. I would like to start by what may be deemed a procedural matter, but I think it typifies what has happened in this case the entire time it's been pending. On page 9 of the appellee's brief, they question whether the Burge estimates or proposals are in fact in evidence according to Civil Rule 56C, and whether they're properly before the court. He claims that, or Martin's claimed that those exhibits are not, and I submit to you that this is absolutely a misrepresentation. If you examine D. Martin's affidavit, which is Exhibit 1 to the motion for summary judgment filed on her behalf, they reference Exhibits E through H, which are the Burge proposals, and state that these repairs were suggested by Burge, never completed. There's a similar paragraph of number 11 in the affidavit of Thomas Martin, which is attached to his motion for summary judgment as Exhibit 2. Likewise, the exhibits in question are attached to the deposition of D. Martin as Exhibits C, D, and E, and filed with the court, and are referenced on page 10 of that transcript. And on page 7 of Thomas Martin's deposition, he identifies the same exhibits. So they are in evidence. In the same vein, the appellees the sellers go on to argue that the home inspection repair report is not properly in evidence when it's Exhibit 1 to his brief, or their brief. Obviously, the court's well aware if one party places any evidence in the record and there's no objection, it can be fairly considered by this court. There's no reason for the Petroskys to re-enter, attached to its motion for summary judgment, exhibits that are in fact part of the record through the depositions and part of the records through the motion that brings us, very motion that brings us to this day in this argument.
Does the Drescher burden shifting at any point put that on you to have had that report
No, it's
attached?
in evidence. It's in the record. And I did put them in the record. And when I filed the exhibits that go with the depositions, I filed both of these depositions. The exhibits were attached. They're in the record. But even had I not done so, him doing so to his motions for summary judgment as exhibits without an objection from me renders them fair game for anyone to argue. Now, I respectfully suggest to this court that the significance of the Burge proposals are extremely important in this case. And document why we believe the trial court lost its way and failed to fairly consider the evidence adduced by the buyers in a light most favorable to them. But what the Burge invoices or proposals are is work that needed to be done on this very house concerning the defects that the buyers claim were never disclosed. It is uncontested that the Martins, the sellers, had these invoices in their possession and that they outlined the work that needed to be done on the roof. This is the same work that was not mentioned in the home disclosure form. Mr. Martin admits he assisted his wife in preparing that form. She admits she did so. I don't believe that's in contention, nor is it being contested that they did not say that any repairs were done to this roof within 5 years, when in fact they were. In their depositions, they admit that they made no efforts whatsoever to verify when these repairs were made, and yet they some repairs were made to the roof, but the repairs that were made to the roof that were not made to this roof, I'm sorry, are the subject of this lawsuit. There's a $49,700 reconstruction of this roof that is needed to rectify this matter.
All right, sir, I guess I need to stop you there, because when I read in your brief, nearly $50,000, and I'm glad you used the word, so your expert is talking about a reconstruction. Right?
Absolutely.
Changing the pitch or something of that nature?
What's unusual about this roof is it's not constructed with rafters like roofs, as everybody knows. This roof has 4x6 double tongue and groove structural elements that stretch from the ridge board to the wall and past. And they constitute not only the decking, but the rafters. And they're put together. As a result of this, there's no insulation. The people that came out with this product and the builder felt that 4 inches of wood would provide sufficient insulation. That's not true.
Well, did your client's inspector, sounds like he did a pretty thorough job, did your client's inspector bring that to anyone's attention?
No, and that is one of my points that I wanted to argue that I think is so significant as to why the trial court lost its way. The trial court actually concludes that since they had an opportunity to inspect, and they did, there were no hidden defects that were obligated to be disclosed by the sellers. I submit to you that had the court used the proper focus and resolved any doubt in favor of the buyers, they would have looked at that report. It's an extremely thorough report, and seen that this structural defect was never mentioned. What was mentioned, and which is cited by both parties in their briefs, is that there were some repairs to the roof, and the seller should inquire more. Well, the seller did inquire more, and that's what the purpose of the home disclosure form is. And they indicated in that form that there has been no leaks for the last 5 years and no repairs for the last 5 years. That home disclosure form answered any and all questions raised by the very detailed home inspection. And as a result, the trial court should have inferred from that this defect was hidden, because a very competent and very thorough home inspector didn't find it. And to buttress that argument, it's also suggested by the sellers, what happened, I just lost my train of thought. The fact, in this case, as argued by the sellers, there was a slight renegotiation of the purchase price based upon the home inspection report. And that renegotiation dealt only with radon gas and mold, which was immediately remediated with no problems and required a very small deviation from the agreed price. Had my clients been aware that the roof was defective and there was almost $50,000 reconstruction needed, they would have renegotiated that at that time. Rather than viewing that inference in the light, or making it in the light most favorable to the buyers, saying that had they known about this, they would have renegotiated like they did the minor things, the trial court concludes the opposite and concludes that the buyer didn't make out their burden to prove that the fraudulent representations were either knowingly or recklessly made. But there is plenty of evidence that does that, and the most important of which is the Birch proposals. Martin's, the sellers were on notice that this work needed to be done. They got estimates from the Birch building company to do it and didn't do it. Even their own affidavits say these were suggested repairs. And even though we put some shingles on the roof, we re-roofed the roof with shingles and repaired spots where they needed to be replaced and recovered the whole roof and put some wood in there, we had no idea that there was leaking. I submit to the court again that had the trial court had the proper focus on that issue, they would have had to conclude that this is a legitimate question of fact that requires the trier of fact to solve. It was not a proper subject for the trial court to weigh and conclude that despite this evidence, despite the fraudulent representations in the disclosure form, despite the fact that the sellers actually lied in their affidavits and said the Burge invoices proposals were left at the house prior to closing. They admitted in their depositions they were not. Taken as a whole, all of these things and others have to show that there was at least a legitimate question of fact to be inferred had the court had the proper focus, which we respectfully submit it did not.
You have just 5 minutes. I don't know if you intended to retain any time for rebuttal.
I do want to reserve a little bit for thank you.
Thank you.
May it please the court, my name is David Paz and I represent the Martins. I wanted to, I kind of set up my arguments, I thought, that I wanted to make in my brief, but since the time I wrote my brief, there was another case that actually came out that supports my position, and it kind of takes up some of these issues that I wanted to share with the court.
Did you file a supplemental?
I did not.
You haven't filed that with the court?
I have not.
And it's come out since the time you filed your brief?
It came out, yes.
Okay, but if you haven't notified the court, then, or opposing parties, we really can't consider that
Okay.
today.
All right, all right. Then let me go to the issues that were just being argued. Okay, first of all, the Burge, Burge quotations and proposals. Okay, they're argued as being very important, and yet no one ever bothered. Okay, certainly the plaintiff never bothered to take the deposition of anyone from Burge to determine, okay, exactly why they were out there, okay, to try to dispel any kind of an idea that the Martins were not telling the truth and that they had not had any problems with their home. They said clearly that they had the roof put on for cosmetic reasons, and they had never had any kind of leaking issues with the roof. So if you actually take a look at the residential disclosure form, okay, what it asks are, do you know of any previous or current leaks or other material problems with the roof or gutters? They said no. There is no indication anywhere that there was any kind of problems. And then and only then, if you answer yes, you're supposed to then then you're supposed to tell what you did to have it remediated. Okay. Well, they didn't have any problems with the roof. The other piece of information that's important on the residential property disclosure form is the fact that they vacated the property on October 15th of 2012, almost a year before this property had actually transferred. So they hadn't been living in the house currently if something had developed, although you would have thought that that the inspector would have certainly been able to find any problems, and in fact he did. And just very quickly on the issue that the court brought up as to the $49,700, that was for a complete, that's for redesigning the roof that's been there since the house was built. Okay, and it was not submitted by way of an affidavit. Okay, it was attached as something that was, there's nothing in here that says, yeah, this has to be done because there was a leakage in the house or anything like that. There was no nexus between that report and any kind of leaks or anything that Burge ever did. But the report that was done by their own expert, okay, and this kind of goes back to the whole Lehman versus Benz case. Once you're put on notice that there is any kind of a problem, then it's up to you to go ahead and further investigate. And this, I just don't even know how this could be any more clear, because here's what the inspector says in his report. Evidence of repairs on the roof at various locations. And then he directs, inquire with the sellers regarding history of repairs and any potential warranties. Okay, now, had they done that, okay, then it would have given Martins an opportunity to say, okay, fine, we're going to go and look to see what paperwork we have, or we'll give you whatever we have. I mean, obviously they weren't trying to hide it from them; they left it at the property. But here's when I asked the question about further inquiry into this matter. Here's what the plaintiff testified to. It says, did you have any understanding as to how old the roof was? Answer: we knew it had been replaced recently, but we didn't have any idea. I think we estimated 10 years. did you ask to see anything regarding the installation, any invoices, paperwork, warranty information? Answer, no. So even after getting the report from their own expert, okay, who clearly identifies that there are issues with the roof, okay, they didn't do what both the law requires them to do, okay, and what their own inspector suggested that they do, is make a further inquiry, which they, by their own admission, never did. So when the court went and evaluated this, they weren't looking at evidence and weighing it as suggested, by the plaintiff in this case. They were actually taking a legal stance, and actually on page A7 of the court's court's judgment, they indicated that the case was very much like a case decided in this court, Hoops versus Kelly, okay, and said, okay, once alerted to when a problem arises, once alerted to a possible defect, a purchaser may not simply sit back and then raise his lack of experience when a problem arises. Aware of the problem, the buyer has a duty to either to make further inquiry to the owner, which was suggested by the inspector, who is under a duty not to engage in fraud, okay, or to seek the advice of someone with sufficient knowledge to appraise the defect. And in fact, in the inspection report, they were also encouraged to have what he called, at a minimum, a roof tune-up, to go there and have a qualified person come out, evaluate the roof, and take care of any repairs and things that needed to be done. None of that was ever taken care of. None of that was ever done. So the court, in looking at this, was looking at the legal issues and the issue that has never been addressed by the plaintiff. Okay, not in his brief, even though it's essential to his fraud claim, which is justifiable reliance. Okay, there is not a mention of justifiable reliance almost anywhere in the brief that I could see, unless it was a reference that he quoted from another case. But there's no argument on the subject at all, and it's an absolutely essential element of the fraud claim that he has to make in order to overcome the as-is provision in the contract. So, and in fact, the court also cited another Ninth District case, Ponder versus Colt, okay, and again, which turned on the whole idea of justifiable reliance. And it says where you have, basically says a home inspector, holding that appellants could not have justifiably relied upon appellee's alleged non-disclosure and misrepresentation of water problem in the basement, where a home inspection and general observation of the basement placed appellants on notice of water damage. So once the inspector had been out there and said, hey, you have some problems with your roof, okay, it's not, and he mentions the term all over his brief, ice damming. Ice damming is a term that he uses. It's not supported by, not by his experts, not by the FERS reports, not by anything other than the affidavit of his client, okay, but there is no ice damming, okay, that anybody has determined exists in this home at any time. So the expert, their own expert, actually had really set the stage for them to make further inquiry. In fact, the plaintiff in this case did in fact take notes off the expert's report and noted problems with the garage roof, problems with mold, problems with the gutters. Okay, so he was fully aware of all of this stuff and chose not to take any of this stuff on. But there certainly is no evidence of fraud. On the one hand, there certainly is. They can't prove any fraudulent statements being made. The other, and let me just look back up, and the other thing that he says in his brief is that they have certified disclosures or verified disclosures. Well, no, that's not what the disclosure statement is. The disclosure statement is just is an opportunity to put down anything that you're aware of, that you have actual knowledge of. It's not a no or it's an actual knowledge. It's an actual knowledge standard. As a matter of fact, if you take a look at, and the statute actually says this. In fact, RC 530230 F1, it says it relieves the seller of any liability for damages allegedly arising from any error in, inaccuracy of, or omission of any item of information required to be disclosed in the property disclosure form if the error, inaccuracy, or omission was not within the transferee's actual knowledge. Moreover, sellers have no duty to inspect or acquire knowledge regarding defects of their property. Rather, the duty to conduct a full inspection falls on the purchasers and the disclosure form does not function as a substitute for such an inspection. And that's really what they're trying to do here, is to use the disclosure form as a substitute for this inspection that they had. Probably the most thorough inspection that I've ever seen in all time practicing law. So they were well aware of these
Counsel,
problems. They chose not to make
counsel.
further inquiry.
Counsel, one of the things that you mentioned was actual knowledge and that they had not made any fraudulent representations on the, you said that you could affirm on the basis of no fraudulent representations being made and/or justifiable reliance, no justifiable reliance.
Yes.
But I think that's what he's arguing with the fraudulent statements, that the court was weighing credibility in regard to the fraudulent statements when the homeowners were saying, oh, we did make a mistake, but we didn't mean to. Isn't that a weighing as to who's being
No,
truthful
well,
at that time?
I think he's under an obligation to put forth evidence. He's under an obligation, once they make their statement, to put forth evidence to show that they're not telling the truth. He could have done that by posing somebody at Burge who said, oh yeah, this thing was blatant like a sieve, that's absolutely wrong. Okay, but there's nothing in the record, none of the evidence that he showed that would show that they had some kind of actual knowledge different than what they said that they did. Okay?
What about the estimates?
What about the estimates?
You mean the invoices?
Yeah, the invoice, I'm sorry, the
Yeah,
invoices.
the invoices, they testified, yeah, they were in the actual invoices, they were what they paid to have done on their home. They don't deny that they had it done, they deny that they had any leaking. And there is nothing, I mean, if you're talking about the contents of those proposals, okay, the proposals themselves, I mean, the fact that they existed and they were paid was testified to, but nobody from Burge ever said that, that the content of those proposals, okay, were true or complete or accurate or anything. And there's nothing in there that actually contradicts anything that they said. They said that they wanted to have the roof, they had to have a roof put on, they did. And at the same time had any issues taken care of that needed to be taken care of, that were, underlying issues. And they had it taken care of. But even if that wasn't true, even if you give them that point, okay, there's no getting around the justifiable reliance argument. You can't rely on the statements, whether they're true or not. You can't rely on the statements if they have an inspection that points out the very errors that they're complaining about. And that's exactly what happened here. Any other questions?
Thank you.
Okay.
Thank you.
And with that, I would ask that the court affirm the decision of the trial court. By the way, I also have many court cases cited in my brief that support, granting summary judgment under these very circumstances. Conversely, there is not in the appellant's brief. Thank you.
Thank you.
I have to respectfully argue that the record is replete, and so is my brief with quotations to the record as to facts that would lead to the inference that the sellers knew that there were material misrepresentations. The largest of that is the Burge proposals. If you read the affidavits carefully of the sellers, it says these were suggested repairs. These repairs were not effectuated. They were on notice. They had actual knowledge they needed to do these things to the roof. They lied and said that they gave these things to my clients before closing, yet in their depositions they admitted they did not do so. All these things permit the inference that there's a question of fact as to fraud or their intent, whether they actually knew. Basically, what they're saying is the sellers are charged with knowledge and documents they weren't given until after closing, but yet which they think they can rely on now.
Counsel,
It just doesn't work.
Counsel,
Yes.
excuse me, did the Burge proposals address the construction of the home? As you pointed out in your brief, the term roof is different than topmost structure. It's more than just, your experts considering it to be more than just shingles, so to speak. So did the Burge proposals give some indication that the whole structure of the top of the house needed to be remedied.
Yes, and hopefully I'll be able to find that for you in 1 second.
Well, I'll look at it eventually. I don't want to take up your time.
No,
If you're
it
telling me yes,
does.
then that's
It
fine.
actually speaks to replacement of the tongue, I believe here. Exhibit H concerns the replacement of the tongue and groove cedar structural portions of the roof.
Well, we,
When you have to when you have to replace the structural components of a roof, which Burge is proposing, then yes, the answer to your question is yes, and Exhibit H attached to the motion for summary judgment documents that. I mean, basically, what the seller's brief did and what the trial court did in this case was merely beg the whole issue. The Martins admitted they did not make the disclosures as they said in their affidavits. The Martins admitted that you cannot see the repairs that were made, which weren't sufficient to correct the whole defect because they put a cosmetic roof over the top of it. The proof of the pudding has to be, as the council has recognized, the most detailed home inspection report he ever saw failed to disclose this. I mean, just because their expert said you need to make some inquiries about when this roof was done and whether or not it's too old, it has nothing to do with rebuilding the entire roof. And again, had anybody, what does a buyer to do? He hires the best inspector money can buy, the most thorough one in the area, to examine the roof. The defect is not disclosed. It turns out that the sellers actually leave evidence after the closing that they were aware that there were defects in this roof. The ice problem did not arise in the icicles within the year that the Martins moved out of their house and it was finally sold. That's just not viable. And besides, there's no evidence in the record to support that. At this point in time, all of this evidence, including the home inspection report failing to disclose this, the renegotiation based on 2 minor defects, the Burge proposals for work that was never done, all lead to the inference that fraud occurred here. And this is confirmed by the fact that Mrs. Martin, the seller, did not disclose in her home disclosure form that repairs were done with the roof. They've admitted they didn't do that within the 5 years. They admitted they made no effort whatsoever to verify when these repairs were made, even though they admitted their depositions they weren't sure at the time. And basically, the record in this case, I honestly and respectfully submit, scream for the fact that there's a question of fact here as to whether fraud was committed. And therefore, the trial court lost its way when it weighed the evidence and resolved all these issues against the buyers by saying they haven't met their burden. So I respectfully suggest that this case should be remanded.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted to our website and that of the Supreme Court.